Good morning, good afternoon, wherever you are in the world. Thank you so much for joining us on this session today on limits and possibilities for international human rights and gender agreements. My name is Keneilwe Tsotsotso, and I will be the moderator for this session. Just to give you some background on this topic, what we all know is that we are entitled to human rights. These include the right to live free from violence and discrimination, to enjoy the highest attainable standard of physical and mental health, and to be educated, to own property, to vote, and to earn an equal wage. But across the globe, many women and girls still face discrimination on the basis of sex and gender. Gender inequality underpins many problems which disproportionately affect women and girls, such as domestic and sexual violence, lower pay, lack of access to education, and inadequate healthcare. For many years, women's rights movements have fought hard to address these inequalities, campaigning to change laws or taking to the streets to demand their rights, to make sure that their rights are respected. And new movements have flourished in the digital age, such as hashtag the Me Too campaign, which highlights the prevalence of gender-based violence and sexual harassment. Through research, advocacy, and campaigning, Amnesty International pressures the people empowered to respect women's rights. And for our session today, we'll be looking at women's rights and what women's rights actually are. Today, I am honored and privileged to introduce our guest speaker, Dr. Satang Nabaneh, Director of Programs and Research Professor of Law. She is a legal scholar and human rights practitioner. Her expertise spans through international human rights and monitoring mechanisms, human rights in Africa, gender equality, and women's rights in democratization in Africa and comparative constitutionalism. She has substantial experience conducting research, including systematic desk reviews and rigorous interdisciplinary field research in multiple countries. Her work has been published in peer-reviewed academic publications such as the Health and Human Rights Journal, International Journal of Obstetrics, African Disability Rights Yearbook, and Constitution of the World, and the yearly iConnect Center Global Review of Constitutional Law. I am so honored to have you on this call, and I'd like to hand over to you, Dr. Satang.
Thank you very much, Keneilwe, and thank you for the invitation to be part of this very important space and conversation, especially on the topic. I will start. I think I do have a PowerPoint slide, which will also be projected, but I think part of, and thank you for the very kind introduction. That was kind of you. I wanted to start on a personal note in terms of, recognizing my own positionality as well as few disclaimers. Obviously, the theme and the topic itself is a broad topic. It can go in different directions. And so I come into this space as an African, as someone that was born and raised in Africa, from one of the smallest countries in mainland Africa, the Gambia, so pretty small. A lot of people don't know where Gambia is. I usually have to say it's the line in between where Senegal is, anyway. But that also means that I also come into this space with growing up in a society that I realized at a very early age that men and women were not treated equally. And I, during the course of my lifespan, have been in spaces where, as majority of African women, but also majority of women around the world as well, have continuously have to contend with, for instance, issues around gender stereotypes and other challenges as well. So I am really somebody that considers herself a global citizen that is committed to bringing especially marginalized and fringe voices, and committed to fighting injustice and the marginalization of the most vulnerable in society, and recognizing, obviously, as a human rights practitioner. And I do like to say that I wear two hats. I think you mentioned it, as a scholar activist or as a scholar human rights practitioner. Because part of it is bridging the divide between academia and activism. So I started as a child art activist when I was 8 years old. And so that sort of has led me into the academic part. But I think part of it has always been, how do we, as academics, legal scholars, use sort of the knowledge, the research that we do to support programming to support the development of policies and laws, as well as creating the conducive legal framework for the realization of human rights. As you rightly said, just quickly, I work at the Human Rights Center, which is based at the University of Dayton in Ohio in the US. And the Human Rights Center is a center that tries to bridge the gap between theory and practice, and so does a lot of work, especially in terms of engaging human rights practitioners globally, as well as education in human rights as well. But part of it also is recognizing, I think, and as a lawyer, I know we're always guilty of being, boring with our legal jargons and things like that. But part of it, especially with regard to the topic itself, is recognizing as well that, the work that has been done, especially advocacy work that has been done to support the development of human rights and its evolution, we will look at as well, has been very much rooted in terms of the everyday experiences of people on the ground, the work that people are doing. So whilst obviously, quote unquote, you have the legal experts who are the lawyers and so that don't do quite a lot of work in terms of not just drafting and advocating for laws, but also engaging in strategic litigation. Part of it has always been that it is the everyday people through their actions, through their conversations, and through their reflections that we realize human rights in general in our daily lives. And so just coming back to the topic itself, I think, part of it is acknowledging that, over the past decades, there has been considerable work done, especially in relation to international human rights law, which we've seen, especially in terms of centering women's rights and recognizing gender equality, which has been recognized in international human rights instruments, but also in terms of regional human rights instruments, as well as national laws and constitutions, and we'll look at that a little bit, especially around the codification of the right to non-discrimination. So just briefly, just starting at the global level, in terms of the UN system, we know that, for instance, the UN Charter in 1945 recognizes that human rights and fundamental freedoms should be enjoyed by everyone. Since then, obviously, with regard to the history, human rights instruments have exploded, really, especially in terms of affirming, as I said, the rights of women, but also centering that women and men must equally enjoy the human rights that they enumerate without discrimination. This has been reflected both in terms of the Universal Declaration of Human Rights in 1948, especially the preamble, which recognizes the rights of all members of the human beings, and that is the foundation of freedom, justice, and peace in the world. And this has led to, and when we talk about, for instance, the International Bill of Human Rights, we're talking about the UDHR, but also in terms of its codification, both in the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social, and Cultural Rights. And these are human rights instruments that deals with, obviously, separately in terms of specific areas of rights, but at the core of it also recognizes the right to discrimination, the right to non-discrimination rather, as well as the centrality of gender equality. At the UN, when we talk about women's rights, the key human rights, women human rights instrument that has sort of influenced both regional as well as national legal reform is the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, which was adopted in 1979 and really does a great job in terms of it being foundational. Obviously, there are, genuine criticisms around its limitation, especially in terms of not addressing specific contextual issues. But over the years, especially with the treaty monitoring body, which is the CEDAW committee, it has expanded on these human rights issues, especially related to, for instance, traditional harmful practices, as well as others. So there has been subsequently general recommendations and general comments in terms of, more providing better guidance, if you can say so, in terms of state obligations and the work that they are supposed to do, especially in the realization of the rights that are enshrined in CEDAW. Just in person, and I'm not going to go in depth into this, other human rights instruments that are relevant. I mean, all of them are relevant, but especially for girls, because part of it is when I talk about women's rights, I also mean and include girls' rights, right? And so the Convention on the Rights of the Child, for instance, is the children's rights instrument, and is useful, especially in centering the best interest of the child, as well as other principles such as non-discrimination, participation of the girl child, and so forth. And as I said, that's part of my history. That's how I got into the space as a child right activist, and eventually getting into women rights issues as well as broader human rights issues in that sense. In addition, the Convention on the Rights of Persons with Disabilities, which was adopted in 2006, which is the first treaty that specifically deals with persons with disabilities, also has specific provisions around women with disabilities and recognizing their multiple and that their subjectivity to multiple and intersectional discriminations as well. And obviously, I mean, we cannot, there is the logo itself. I mean, we cannot talk about global consensus documents and agreements without actually talking about the Sustainable Development Goals, which we know at the center of it really is based on the advancement of gender equality and the leaving no one behind as well. So part of this is really, especially with Goal 5, centering gender equality and the empowerment of all women and girls for the realization of the goals that are enshrined in the SDGs. I'll come to the regional level. So to say my focus and my work has mainly been focused on the African human rights system. So whilst drawing a lot of comparative best practices, obviously, and utilizing, I mean, you cannot do human rights without using the global human rights as space. But really centering on the work that is being done at the regional level in terms of advancing the rights of women and girls in the continent. So obviously the African Union, which as we know was, oh, that's me, yay! The African Union, which was formerly known as the Organization of the African Unity, adopted the Constitutive Act in 2000. And Article 4 of the Constitutive Act recognizes the promotion of gender equality as one of the principles to which the African Union should function. And as a result, at the regional level, we've seen major commitment to gender equality, specifically, for instance, and various examples. We've seen gender equality being enshrined in the African Charter on Human and People's Rights, which is the human rights instrument at the continental level. There is a specific provision, Article 18, that provides for women rights, but also part of the criticism, valid criticism, has been that the African Charter, even though all the rights, women have also the equal opportunity to enjoy those rights, but the African Charter is limited in a way that it doesn't really address the wide array of women's issues and rights needed as well. And so as a result, and a lot of advocacy on the part of African women in the continent, the Maputo Protocol, it has a long name, I'll say Maputo Protocol, but which is a protocol to the African Charter on the rights of women in Africa, provides a comprehensive framework to guide rights-based action, especially around advancing women's rights, advancing gender equality in the continent. I am obsessed with the Maputo Protocol. I mean, majority of my work has been in terms of supporting the African Commission, which is the body that is responsible for the implementation of human rights instruments at the continental level, in terms of developing norms and standards, in terms of developing and training states, especially regarding their obligations as well. Yeah, so you can, okay, so I think it will be like slide 2. Thank you. Yeah, so the Maputo Protocol itself provides, as I said, is unique in a sense. So it's, yeah, thank you. So the Maputo Protocol is unique in a sense in terms of that it draws a lot. Obviously, as I said, CEDAW has influenced both regional as well as national level legal reform. And so the Maputo Protocol draws a lot from CEDAW. But the Maputo Protocol is unique in a way in that it contextualizes the rights within the African context. So taking the specific needs and challenges of African women and girls in the continent. And so as a result, the Maputo Protocol is different because, for instance, it has specific provisions on female genital mutilation, which, as we know, and I do quite a bit of work on that, the continent has one of the highest prevalence rate despite legal reform around the issue. But also it recognizes other rights. For instance, we know, and I'll talk a little bit about that, it has a provision that authorizes medical abortion, especially in cases of assault, incest, and so forth. So it is a great tool for African women and girls, and a comprehensive framework that really places the centrality of women's rights within the African continent itself. As I said, the African Commission, which oversees the implementation of the Maputo Protocol, has also, in addition, similar to what the CEDAW Committee has done, developed, as I mentioned, I have been engaged in several general comments and general recommendations around the HIV provision, but also on Article 14, Article 14 around provisions on sexual and reproductive health and rights, but also has a joint general comment with the African Committee of Experts, which oversees the implementation of the African Children's Charter on ending child marriage. And currently there are processes in terms of developing another joint general comment on FGM. So in a way, at the regional level, there is a conducive space for this. And one of the mechanisms that have been really useful within the African space has been, for instance, the establishment of the special mechanism of the Special Rapporteur on the Rights of Women in Africa, who currently is Commissioner Janet Salanjai from the Gambia. And part of the work that the Special Rapporteur does, especially, is in terms of leading the development of norms and standards, but also putting and centralizing the issues of women and girls within the African agenda as well. And at the continental level as well, we've seen, especially with the AU, that there has been quite a bit of effort. So similar to what we have with the SDGs, there is Agenda 2063, which also centralizes issues around gender equality as well. And the African Union has really, the African Union Commission has, for instance, in 2018, also adopted a strategy on gender equality and women's empowerment, which really also, especially in terms of issues around representation and women in positions within the African Union, there has been progress in relation to that. So in a sense, while there are specific human rights instruments, both regionally as well as internationally, and we can go, I think, the whole day just talking about the influence of these norms and standards at the national level. What we've seen in general is that women's rights have been mainstream within laws and policies, but within structures as well. And we can go to the next slide. And whilst this is great, obviously there is a lot of progress, as I said, especially around gender equality and women's empowerment. We also acknowledge its limitation as well, that the progress has also been a bit slow, whilst we have progress in quite several areas, as I said, especially in terms of recognizing certain discriminatory practices, for instance, as human rights violations, for example, FGM. There is also a slow pace in that, and I'll talk a little bit about some of the issues that I shared here just briefly. I think one of the issues with regard to international human rights itself, international human rights law itself, has been really around conceptual and practical problems. So part of it has been in terms of how international human rights instruments are developed and developed in a way. So one is its heavy reliance, and this is a major criticism, for instance, of the CEDAW approach in terms of its reliance on comparison between, for instance, women and men, which is in a sense problematic, right? Because part of it has been, and we've seen this especially in the work that has been done in the continent, is that this doesn't, for instance, directly address or recognizes the varied natures of gender, the varied gender identities, for instance, which do not technically conform to the duality of male or female, right? And also international human rights law or instruments in certain cases do not also address, for instance, discrimination between groups of women. I mean, and that's a major problem, because part of it has been really, and we've seen it, has been the reluctance, for instance, of international human rights treaty monitoring bodies in terms of addressing issues, for instance, lesbian issues, as well as have been silenced, for instance, around transgender discrimination. So there has been a lot of conversation, even at the continental level, in terms of whether women's rights include trans rights or trans women are women, right? And so, and that is even within the women's rights movement. So there is a lot of, in a sense, and we've been having this conversation, there is a lot of siloed ways of doing things, not just at the regional level, but which is also very much reflective of the global women's rights movement in terms of, I will just deal with, say, for instance, issues around gender-based violence, but not touch issues around violence against transgender people, for instance, or I will deal with political participation and women's rights issue and other women's rights issues, but I'm not going to deal, for instance, with issues around decriminalizing sex work. So whilst we acknowledge, and it is important to say, whilst we acknowledge that the women's rights movement and women in general, including African women, are not a homogeneous group, it is also vital as well in terms of just also acknowledging the limitation of law itself, especially in terms of addressing the varied nature of this discrimination, especially if these women do not fit in within, you know, the clean boxes that we've created in terms of the binary between male and female as well. And this also really extends to even within the provisions, for instance, that we have around family law, which usually understands this as the basis that women's experience of family life, for instance, is that they are married and then they are heterosexual, and doesn't really address to the catered spaces in which they do not fit in within these categories as well. So that's one, but also I think part of it is also acknowledging, for instance, that whilst there are obviously legal reforms, and as I said, we could go a whole day just looking at the legal reforms that have happened at the continental level in various African countries, we also recognize that discrimination itself, it's also very much embedded in the laws themselves, as well as in the judgment. So one, just to say a quick example is this idea that in our various African countries and our various African constitutions, most of our legal systems are plural legal systems. And so a major part of this has been that whilst the Constitution tells you that you have the right to be not discriminated against based on your sex, on the other hand, it's saying, oh, wait, based on your religious laws as well as your customary laws, we can take this back. A good example is the Gambia, where we have, and this is very much reflective, as I said, of quite a lot of African countries. So in the Gambia, for instance, we have this where there is a specific provision around non-discrimination, but then there's another article that says, because of customary law and recognizing customary law, that will not be considered discriminatory as well. South Africa, for instance, has, whilst has a plural legal system, it also has provisions that says, for instance, and as well as in other countries, that says, for instance, that whilst recognizing customary law and other laws that are applicable to people, that it should not also be discriminatory against fundamental human rights. So part of it is really in terms of how do we interpret those laws, and we know that the setup of courts and the people that are judges. Whilst we have progressive judges, we also need to acknowledge that they also don't live in a vacuum. They live in patriarchal societies where they've been socialized in terms of how women's rights and how women are seen, especially in their traditional roles. And so that is why there has been quite a bit of push in terms of one, asking courts, for instance, to ask the woman question. Asking the woman question means, what does this mean within this woman's context, especially in terms of taking cognizance of the multiple as well as the intersectionalities of that woman and the context that they find themselves. And there has been quite a bit of projects, that is the feminist rewriting projects, in which people have taken judgments to write it or rewrite it from a feminist perspective. And so that has been quite a bit as well. I already spoke about the limited knowledge around multiple intersectional forms of discrimination, but also understanding, as I said, whilst there has been a lot of progress in terms of laws and policies, there also continuously also is a violation of women's political, civil, and socio-economic rights. And we can delve deep into all of these examples, and I'm happy to engage further with some of these specific examples, especially during the Q&A. But part of it, and just to give a quick example, part of it has been, for instance, when we talk about women's limited ownership of land or asset, we know that part of this is really rooted, for instance, in our inheritance laws. And this has, for instance, led to the process which I was engaged in at the African Commission level, where a general comment has been developed in relation to this. And then just other examples around harmful and discriminatory practices, gender-based violence. We can spend the whole day talking about that. especially in terms of the limitation of government responses and approaches around this, but also very much rooted in terms of the laws that we currently have. So just a quick example, especially around abortion and reproduction, a key part is acknowledging, for instance, that Africa has the undue burden of the majority of maternal deaths due to unsafe abortion. And part of this is because our laws are not in line with international human rights standards and norms, but also even where there are progressive abortion laws, like in the case of South Africa, due to several barriers and limitations, it has led to women, for instance, going for quick or back alley quick abortions, which have, in a sense, led to that, as well as other negative consequences as well. And I spoke a little bit about that, but especially around gender-based violence and sexuality, part of it is obviously the deepened silence, especially around transgender violence and what we've seen at the continental level, especially around corrective rape as well. Okay, so we can go to the next slide. So part of this is saying, okay, so we have a very progressive international human rights law space that is progressively acknowledging and constantly evolving to address the evolving nature and challenges that women face, but also issues around gender equality. And these are its limitations as well as challenges. How do we move forward? And so part of this is really in terms of how do we reconceptualize what it means in terms of gender, especially around challenging gender stereotypes. So that is also acknowledging that in terms of developing laws and policies as well as actions, it's also recognizing, for instance, the varied nature of the positionalities that women face, so women with disabilities, migrant women, LGBTIQ plus women, and what that means for them within the certain context that they find themselves. Other things obviously are legal, international legal avenues are vital. So both in terms of the international level, but also in terms of taking both communications as well as cases to these legal avenues. Part of the difficulty obviously with that is knowledge as well as access to resources. And there has been a lot of work around that. But I think for me, with some of these things that I highlighted as the path ahead, is around how do we foster and build intersectional solidarity, especially across globally, across global divides. And so, because part of this, as I said, and that was the example I was given about the siloed nature of the work that we do, right? How do we, in a sense, whilst we have pockets of things that we deal with, also ensure that we centralize women issues at the center in terms of, that even if you're dealing with, or your area of work, for instance, is around, is around women's political participation, that you can also support the advancement of women's sexual and reproductive rights, right? And that acknowledging and coming together as a group has more value than everybody working in pockets, which is important. As I said, thematic focus is important, but also at certain point as well, it makes sense to bring the group together as well. I think then another part obviously is this idea that the global human rights system itself and the structures are very much based on power dynamics. And so part of this is rethinking of how do we rethink of changing as well as altering human rights practices that caters to the local context of women as well, and obviously educating and challenging and changing attitudes remains key. So I mean, I will stop here, and I'm excited to engage with folks. And as I said, thank you for the opportunity. I can go on and on, so I'll just stop here. Thank you.
Thank you so much, Dr. Satang. It has been so wonderful to have you here and just to get your thoughts around, the human rights that we have, women's rights, especially internationally, and the legality. And I think what we've learned here is that there's two systems that are happening and are going on. And it's like, how do we make sure that we integrate these systems to actually work for everyone? So there's a lot of work that needs to be done there, but I'd like to thank you so much for coming through. And I hope that we will engage more on this topic. So thank you so much.